The interplay between the appraisal clause and arbitration. The appraisal process and the arbitration process both act as forms of alternative dispute resolution. Both are very mechanically similar, and thus courts often conflate the two terms. Furthermore, numerous courts around the country have taken guidance from cases and statutes relating to arbitration, causing a state-by-state split. This has caused a majority view and minority view. The majority opinion holds that insurance appraisal is actually distinct from an arbitration. A number of basic distinctions have long prevailed between an appraisement under the standard fire policy and an arbitration. An agreement for arbitration ordinarily encompasses the disposition of the entire controversy between the parties upon which judgment may be entered after judicial confirmation of the arbitration award. In contrast, an agreement for appraisal extends merely to the resolution of the specific issues of value and the amount of loss, with all other issues being specific issues of value and the amount of loss, with all other issues being reserved for a determination in a plenary action. An appraisal is an informal, independent investigation conducted by individuals who base their decisions on their own knowledge. An appraisal is generally conducted without hearing or judicial inquiry. In contrast, arbitration is a quasi-judicial proceeding, complete with formal hearings, notice to parties, and testimony of witnesses. Based on these substantive and procedural differences, numerous jurisdictions have determined that appraisal clauses included in insurance contracts are distinct from agreements to arbitrate. To date, this continues to be the majority rule in American jurisprudence. However, an emerging trend in several jurisdictions has shifted this long-standing traditional view. For instance, courts have explicitly held that appraisal is a species of arbitration.
Depending on your insurance policy, many insurance policies will give the option to go through the appraisal process. The appraisal process is when both parties get to select their appraiser, appoint an umpire, and that determines a specific, unique set of circumstances pursuant to your policy, typically a valuation of your property damage. This is different from an arbitration, although it's very similar, and Florida law has particular legal distinctions between the two pursuant to case law. But the easy answer is arbitration is presided by an arbitrator that can decide a wider scope of issues than what an appraisal is actually meant.